Good evening. This is the June 28th, 2010 Austin Constitution meetup. I'm Jon Roland. There have been several exciting developments in the news today, and that are very relevant to the Constitution. And perhaps the most important of them is the decision announced today in McDonald v. the City of Chicago. This is one of the most important cases the Supreme Court has decided in its history. It struck down a ban on handguns in the city of Chicago and a suburb. And the reasons why it gave for doing that are extremely important. The lead petitioner in the case argued that the right to keep and bear arms, recognized in the Second Amendment, extends to the states under the Privileges and Immunities Clause of the 14th Amendment. Now, the Privileges and Immunities Clause was itself deprecated by the Supreme Court in the 1868 case of Slaughterhouse. The judges in that case did not want to extend the Bill of Rights as far as it would be if the privileges and immunities were the basis for doing so. And in doing so, they essentially rewrote the 14th Amendment in clear defiance of the intention of the framers of that amendment. They instead resorted to the Due Process Clause of that amendment. And until this time, the Supreme Court has not been willing to overturn the precedent in Slaughterhouse. That means that even today, in this decision, they based the right to keep and bear arms on the Due Process Clause instead of the Privileges and Immunities Clause. Now, what does that mean to us? It means that they are always referring to the ancient notion of due process, which pertains to things that happen between the time that a case is filed in court and the respondent is served with notice of it, and the time when the case is finally settled and disposed of. So due process is about what happens in court and in the events leading up to court and following court. But it's court-centered. It's judicial. Now, there is such a thing as legislative due process or administrative due process, but that's not what's of interest in this case. So, the question then arises, how can the right to keep and bear arms be a due process right and not a privilege or immunity? Now, in my opinion, it isn't, at least for the most part. there are due process issues involved in almost any constitutional case, and almost any constitutional issue. But if we look at the rights in the Bill of Rights, including the Ninth Amendment, we find that some rights pertain to judicial due process, and some are not confined to that. For example, in the First Amendment. The First Amendment says, Congress shall make no law abridging the right to speak, press, assemble, worship, and petition. All right? Most of those things apply to situations before one gets to court. The right there is against Congress making a law. It's not just when it makes a law and then tries to enforce it and you go to court. Yeah, at that point, the courts can invoke due process, but you're still left with the problem that if the fundamental right involved goes beyond the court, beyond the judicial process, then it's not just a due process right. The same thing applies to the right to keep and bear arms. The right to keep and bear arms, recognized in the Second Amendment, is not only the right to keep and bear arms for personal defense, it's also the right to keep and bear arms for the purposes of organizing, training, and equipping people as militia. Now, that goes well beyond mere judicial due process. We can see the right being restricted or infringed outside of the judicial process. And the people who are the targets of that infringement having the right and to assert a right through means other than just going to court and suing. So, what is going on here when the court avoids deciding on the basis of the due process clause? And the answer is basically that the privileges and immunities clause is much broader. And if we open the door for recognizing rights that are privileges and immunities, then we open the door to many more rights than we have merely under the due process clause. Now, what kind of rights might those be? In my paper, Presumption of Non-Authority and Unenumerated Rights, I explain that there are two broad categories of rights recognized in the Bill of Rights. The first major group are a right to a presumption of non-authority. Now, that is largely a due process right, but again, it is a right to challenge an executive official or a legislative official if he gets out of line, and not just to take the case to court. The second major category is the right to have the means to supervise public officials. This may include information about their income and expenditures, about their activities, and of course the means to intervene to get them to stop doing things that are unlawful, such as a writ of quo warranto, or a habeas corpus, or certiorari, or mandamus, or procedendo. These prerogative writs were established in history in order to provide people with a way to intervene when officials get out of hand. And if those options are denied us, if we don't have those remedies, then our ability to bring our public servants under control becomes severely limited. It's not enough just to be able to vote them out every 4 years in an election, or 2 years. That is too, as we sometimes say, the granularity of that remedy is too broad. We needed the fine-grained granularity of being able to pick out particular individuals who are offending and deal with them as individuals. And if we're denied the way to do that by official immunity rules, by closing the grand jury to access by the public, to all sorts of measures that have sprung up over time to keep the people from controlling their servants, then we have a fundamental problem. We begin to lose our remedies, and if we lose our remedies, then although we might have rights, we don't have the effective use of those rights. Rights become denied us as a practical matter. Now, what we have here petitioners base their case on 2 submissions. Now, what this is saying is that there's more than one set of petitioner. There's the lead petitioner, McDonald, but there are also a bunch of amicus filers. And it's mainly the amicus filers that have been arguing due process, because the main petitioner, led by attorney Alan Gura, really wanted to base their entire case on the Privileges and Immunities Clause and striking it and making it effective, reviving it, resurrecting it. And some of the gun rights supporters said, now wait a minute, we don't think the Supreme Court is ready to go that far. We'd better have a plan B. So we're also going to introduce an argument that it's incorporated, as the expression goes, through the Due Process Clause. And that is actually the argument that prevailed. At least for 4 of the 5 justices that voted for overturning the gun ban. Justice Thomas, Clarence Thomas, did buy the argument. Of course, we all know, really already believed that. But he wrote a separate concurring opinion. And in my view, his concurring opinion is the most important one. He may have only been one, but he got it right. And the other 4 in the majority got the decision right, but not for the right reason. And that may eventually force us to return to it in other cases. In a blog I put up today, I raised this issue. But now what we need to do is we need to find a case involving a right that is clearly a privilege and immunity and not a due process. That separates it out from due process so that we can't use due process as a basis for deciding it. Because we really do need still to go after reviving the Privileges and Immunities Clause. Because we're going to need it for other things, a few of which I mentioned here. So, another thing that's interesting, the 2 cities, Chicago and Oak Park is a suburb, maintain that the rights set out in the Bill of Rights apply to the states only when it is an indispensable attribute of any civilized legal system. Now, how about that argument? They're saying that if most, or if there's at least one country that we can consider civilized that does not recognize a right as fundamental, that it's not, and doesn't apply to the states. Now, do you want to live in a state that makes an argument like that? I can think of a lot of civilized countries that don't recognize a lot of rights that I think most people listening to this would be very upset with their state governments if those state governments try to deprive them of it. And who cares anyway what other countries do? I mean, we might care, because we might have friends or relatives living over there, but the fact is that our Constitution is not based upon their legal traditions, their standards, their legislation, their legal cultures. Our Constitution is based only on our own, and all of our legal decisions are supposed to be based on our Constitution and nothing else, not what any other country is doing. I mean, most of those other countries are imitating us and usually doing it poorly. So we should not be looking to them as models. We're the model. They're the imitators. Sometimes they get it right, often they don't. But we absolutely do not look to them as models. So, those are the arguments. The interesting thing is that the justices did not, in my view, the ones that decided on due process grounds, they made a good argument for the right of self-defense being a fundamental right, but they didn't really make a good argument for it being a due process right. And that is a problem that, as I said, we're going to have to address down the road. But we've got our win now. The case now goes back to the trial court, which essentially has been instructed by the Supreme Court to strike down the local gun bans. So those are going away. But now we have, not from this decision so much as in the Heller decision 2 years ago in the District of Columbia, a lot of language about reasonable restrictions. Now, what is a reasonable restriction on a right? Now, the usual standard is strict scrutiny for most of the rights that we call fundamental. What that means is that the only way that they can be restricted is just incidentally toward in the exercise of a delegated power in a way that does not put an undue burden on them. For example, we can say that a sales tax on everything, including newsprint, that's uniform across all commodities, doesn't single out newsprint, it's just, maybe a 5% on everything, is not an undue burden on freedom of the press. On the other hand, if you put a 50% or 100% tax on newsprint, it would probably put most newspapers out of business. And one could argue that is an undue burden on the press. In fact, there have been some countries that have tried that, usually with poor results. So, what is it that constitutes a due burden or an undue burden? Now, from my study of history, it's very clear. Firearms are subject to regulation, but only in one direction. in the direction of making militia more effective. So, for example, you can require people to own certain firearms. You can't forbid them to own any. You can require them to have a certain amount of ammunition for those firearms. You can't forbid them to have ammunition. You can require them to train and drill and organize and practice, but you can't forbid them to do any of those things. The militia clauses and the regulations under them are just like elections. The preemptive power that Congress has to regulate congressional elections is only for the time, place, and manner of the actual election process. Except, of course, for the place of senatorial elections. What that means is that it does not include things like campaigns, to the events leading up to the actual election, or to the events afterwards, except for the counting of the ballots. So, all of these statutes, such as the one that was partially struck down in the Citizens United case, are unconstitutional because they are attempt to infringe on the right of speech and really of the press. And the First Amendment forbids that. The problem there is that the gun control people do not want to just regulate in one direction toward greater militia effectiveness. They want to legislate in the other direction toward diminished militia effectiveness. They want to make us all dependent and helpless so that we can't defend ourselves, so that we have to depend on the police, so that we will vote for larger police forces, larger prisons, more prison guards, more of all of those things. And why? Because the people who take that position, for them, those are constituents. Those are government jobs, and one party over the others favors creating government jobs because most of those government workers will then vote for that party. So for them, the idea of having a vast criminal justice system is good business. It's good for for the results in elections. Plus, they creates lots of work for defense lawyers, trial lawyers, for all kinds of people who then donate money to that party. There's got to be a better way. And the better way is that we back away from expanding the criminal system, the laws, the justice system, and so much that it becomes a power unto itself that ceases to be accountable to us, so that it becomes to become oppressive. And one of the most important things we can do to achieve that is for ordinary citizens to help enforce the law. We can all do that. It's not just a matter of keeping your eyes open and calling 911 if you see something suspicious. It means that people need to investigate, they need to report, they need to all be good journalists. Sometimes they need to make arrests, they need to appear as witnesses, they need to do all of the kinds of work that the police do and can't do because there aren't enough of them. And shouldn't do because we shouldn't be paying people to do that kind of thing. We need to do it as volunteers. So the tendency to professionalize public service work is one of the great threats to our constitutional order. As long as we are doing for ourselves, we are strengthening ourselves, strengthening our ability to deal with any problems that may come before us, strengthening our culture, our civic culture, and in fact reducing the threats simply by the culture that we create. When this country was founded, there was very little crime or very much need for laws or law enforcement. People took care of it themselves. Militia and juries ran local communities. We could do that again. Although we now have voting precincts that are as large as counties were during the founding era. So we need to move government down to a very, very local level, to what I call the village level, the local neighborhood. Group communities of about 3,000 people, no more. Each one with its own constable or sheriff, its own courts, its own grand jury, everything. Right there at the local level, among a small number of people who all know each other. Unless and until we do that, we're going to be faced with an unmanageable situation where everyone, in order to supervise their public servants, would have to put in more hours every day than they have waking hours. When this country was founded, public servants could be controlled by voters spending maybe 3 or 4 hours a week in attending to public duties. Now they'd have to spend 30 or 40 or maybe even much more than that hours a week in order to accomplish a similar result. Most people cannot really afford to do that. In an agrarian society where people are idle about, let's say 5 or 6 months out of the year, during the winter and during the summer, that's one thing. But once you get away from that agrarian cycle, everybody's working 24 hours a day, 7 days a week, 12 months a year. They might be sleeping some of those hours, but they're really still working because they're probably thinking about work while they're asleep. So we have a new kind of situation where, in order to preserve our constitutional rights, we're going to have to reorganize society in a more fundamental way. But let's just attend further to this case. What happens now is that although the Chicago and Oak Park gun bans will be struck down, they're still going to try to regulate guns in any way that they can to make it as difficult as possible for people to exercise the right. So we're going to have lawsuit after lawsuit after lawsuit after lawsuit, hammering away, on a restriction by restriction basis. And we need to all be prepared for that, because we're all going to need to play a part in it. You need to play a part by demanding, for example, that we go to open carry in the state of Texas and elsewhere. Now that there is going to be no restriction on acquiring and possessing firearms, now we need to be able to carry them around. And the restriction on criminals possessing or carrying firearms needs to be further restricted itself. A person should not be denied the right to keep and bear arms just because he has a criminal conviction, unless, in the course of the trial in which he was convicted, the restriction on the right to keep and bear arms was made part of the sentence. If it was not made part of the sentence during the sentencing phase, then it is a violation of the ex post facto prohibition. There needs to be a separate trial or hearing on the question of disabling any right, including the right to keep and bear arms. So rather than trying to do it legislatively, we're going to need to go and with each case where a criminal is convicted, we need to explicitly restrict his right to keep and bear arms or not. But if it's not explicitly restricted, then we may not go back later and add on a restriction, because that is a violation of due process. And of course the prohibitions on ex post facto laws and bills of attainder. So these are all things we need to attend to, things that everyone needs to understand. But if you don't understand them, you can't effectively demand that your legislators act on them. You have to be able to argue these points with the lawmakers whenever you have a chance. So you need to study the stuff at constitution.org and constitutionalismblogspot.com and my other websites, because that's where you'll get the arguments. If you can practice on them, making them on each other for a while until you've got it down cold. And when you're sure that you can fly on your own, then it's time to go out and make those arguments to decision makers. Now, there's another matter that has come up last week on a different subject. A state district court here in Austin issued a temporary injunction to the Green Party not to certify their candidates on the ballot for the November 2nd, 2010 election, on the grounds that the 92,000 petition signatures that had been gathered were paid for by what appears to be a corporation. Now, what apparently happened is that a group that apparently is incorporated up in Missouri paid for another company who is in the business of gathering petition signatures to gather them on behalf of the Green Party, and then they just presented the Green Party with the signatures. Here are 92,000 signatures. You can go ahead and file them. And the judge, in effect, ruled that this was a contribution in kind from a corporation, which is forbidden by the Texas Election Code. The problem with that decision is that the Texas Election Code does not provide for a penalty of denying access to the ballot if the signatures are otherwise valid. They can be fined for it, but there's nothing about making the fine a prohibition, an injunction against certifying one's candidates. Now, we libertarians have been deciding among ourselves what we can do to help out in this situation. We believe in fairness. We don't believe in winning elections by being the only party on the ballot. We like competition. We like to win fair and square. We want any significant party to be on the ballot with us so the voters can have a choice. We're not concerned about how the voters make that choice. Obviously, we would like them to vote for us. But it's not our job to win. It's our job to have and be the best candidates. Choosing the best candidates is the job of the people. And we want the people to have the opportunity to make that decision. So I may be issuing a statement myself, or the party may, which may appear as a letter to the editor or some other such thing. But however it comes down, we want anybody who's listening to this to know that we don't believe that it's right for the Democratic Party to try to knock out a competitor in a lawsuit. If they want it to knock out the Green Party, then they need to win votes. They don't not go to court. And we don't think that speaks well of the Democratic parties, and that they should be ashamed of themselves. So, the case is Democratic Party versus Texas Green Party, and the deadline for appellate review is July the 2nd, when the candidacies have to be certified. So this coming week, we expect to have an appeal decided, and hopefully the right decision will be made. In any case, we're going to do what we can by speaking out to make sure that this very wrong decision is overturned. Okay. Now, I'm going to take a break here, get some water, and then I'm going to go on to another subject. This document is an article called Judicial Reforms Needed at constitutionalismblogspot.com. I'm going to be going over some of its presently 24 items. What I've tried to do here is to just pull together, for many different discussions, a short list, at least as short as I could make it, of the most important judicial reforms that are needed. Now, doesn't include them all. One can always come up with more. And it's not necessarily in order of importance. Rather, the organized more in order of time, the sequence in which they would need to be done, because it's easier to do some of the later ones after you do some of the earlier ones. So, we're not going to be able to get all of these at one time. We need to try to have such a list in mind whenever we go into any discussion of judicial misconduct, or prosecutorial misconduct, or governmental misconduct generally, so that we have a notion, a sense, of why things are going wrong and what needs to be done about it. The first item is to select judges into a pool of judges by sortition, or at random, not by election or appointment, but with some filtering for knowledge and skills. Okay, now what does that mean? Most people don't know what the word sortition means. Sortition is random selection. It's the method we use or supposed to use, for selecting juries, both trial juries and grand juries. Now, in fact, grand juries are not selected that way for the most part. Trial juries start out that way, but there's a filtering process called voir dire, in which the opposing lawyers can challenge some of the members of the jury pool in order to get what they hope will be a jury that is favorable to them, by striking out the ones that they think would be unfavorable to them. Well, what this contemplates could be a fairly complex system. The idea would be to start out with a very large pool of people, which could be ordinary citizens. You select them at random from the general population, say, or from, some might insist, well, we need to select them from the population of lawyers, but there are problems with that. But whatever the population we start with, let's say we wind up with a smaller group, and their job is to decide among themselves to nominate a still smaller group of people for the next round. Now, what we would probably ask them to do is to pick out the most highly qualified legal minds that they know. And there might, at that stage, be a questionnaire asking people if they were selected, would you be willing to serve as a judge? But at this stage, they don't need to be willing to do that. Then you do the random selection again from that pool to get a still smaller pool. And again, they're asked to name the people they consider the best legal minds around. Not necessarily candidates to be a judge, but people who know the law and know judges. They might be legal historians, they could be political scientists, they could be people from all walks of life, but people who know something about what makes a good judge. And so by going from random selection phase to screening phase to random selection to screening, finally you get a pool of at least 10 times, say, of the number you want to pick as judges, and you pick them in the last stage, you pick them at random, and those guys become judges. And again, that next to the last stage, you probably want to ask them if they want to be judges. So now you've got guys who are appointed as judges, but are selected as judges, but the deal is this, that they are assigned to courts for short periods also by sortition. In other words, you have one large pool of judges, let's say all federal judges are one pool. Then at random, you assign them to particular courts, including the Supreme Court. So there's no longer a fixed membership of any court, including the Supreme Court. And they serve for only a limited period of time, let's say a year. Then you have large enough courts with enough judges that you can initially decide cases with a randomly selected panel of 3. That can be appealed to a randomly selected panel of 9, and from there to a randomly selected panel of 27. You can have 28 judges total, so you have one as a spare. So there are 3 levels of trial or appellate review within each level of court, within each tier of the court system. And the judges, there's no way for anyone to know who will be the judge on any given case, or who will be a judge in that court for any long period of time. And because of the randomness of it, the next time that judges are chosen by sortition, there is no career path. You don't improve your chances of promotion by pleasing some powerful interest group, because there is no chance of promotion. You're going to be out. And the only way you're going to get back in is if there's the random luck of the draw. And there's no telling when you're drawn where you're going to be going or what cases you're going to hear. So, moving the sliding up here, the fifth item is to require that decisions of multi-judge panels be unanimous to sustain the claimed power of government against a claim by a citizen that the government lacks such power. Right now, for example, we just saw an example of it, Supreme Court, 9 judges, decides cases by a majority vote. There's nothing in the Constitution that says it has to be a majority vote. Now, we don't know what would happen if Congress passed a law that said that it had to be unanimous to support a power of government against the right by a citizen, but if we adopted an amendment to do that, the judges might pay attention. And that's my proposal. That just as a jury has to be unanimous to convict an accused in a criminal case, a multi-judge panel needs to be unanimous to sustain a power of government. And if they're not unanimous, if even one judge on the panel says that the government does not have a power, then the government loses. Now, in item 6, you'll notice a pattern here. We mandate reversal of any judgment that does not presume non-authority for any official act and requires strict proof of such authority. Now, that would just about have to be a constitutional amendment. But you'll notice that what it does, it doesn't tell judges how they have to make decisions. It's telling the court above them to reverse if they've made a decision in a certain way. Now, obviously, the Supreme Court is not going to be bound by any such thing. But hopefully, if it becomes part of the judicial culture by being enforced at every lower level, it would eventually filter up to the Supreme Court. Similarly, item 7, mandate reversal of any judgment for the prosecution in a trial with mixed issues of law and fact, including all criminal trials in which parties have been impeded from arguing all issues of law before the jury, except issues of law that cannot be argued without disclosing evidence that is properly excluded. Now, that's a sound that's pretty long-winded there. A lot of words. What do they mean? Well, what this means is that you can't just tell juries to vote their conscience. That just does not work. They are there to decide the law as well as the facts in a case. Maybe not decide motions. The judge still decides motions, but the jury needs to be able to review the ways of what decisions the judge has made in the case and the way he's made it, and to decide for themselves whether he did so properly or whether he is exhibiting bias in the case. And to make their final decision, the verdict, on the basis of a review of everything the judge has done. Now, item 8 is to forbid motions in limine to the prosecution in criminal trials. A motion in limine is a motion to exclude evidence. Originally, they were excluded from the prosecution in criminal cases. They were allowed, of course, to both parties in a civil case, and to the defense in a criminal case, but somewhere along the way, judges started granting them to the prosecution, forbidding the defense from introducing evidence that could be exculpatory to his client. So, how did that situation arise? Well, I'm researching the subject, actually, but the simple fact is that the defense needs to be able to put on any evidence they want. There should not be anything excluded. The defense in a criminal trial needs to have all the advantages of any evidence they can put forward, and if some of that is a bad judgment call on their part, then they'll pay the price. But that has to be their decision. And number 9, mandate reversal of the conviction in any criminal trial in which the jury has not been instructed to determine whether the charge is authorized by applicable statutes and constitutions, or they have not been provided with copies of such statutes and constitutions, and of legal pleadings on the arguments in the case. Another long sentence. What this is saying is that the jury needs to know that they're supposed to judge the law. And they start by looking at the charge and saying, is this charge authorized by a statute? And is the statute authorized by a constitution, either federal or state? If not, if they can't find the chain of authorization, then they should acquit. And they need to know they should acquit. They shouldn't just take the prosecutor's word for it that the charge is lawful, or the judge's position that it's lawful. They need to decide for themselves. And if the charge is so obscure, so obviously not related to some provision of the Constitution, then there shouldn't be a charge. Either the Constitution or statutes need to be rewritten to make it clearer what they mean, or the case shouldn't be brought in the first place. Now, number 10 is, what do you do if judges don't do that? Just mandate the suspension without pay on the first offense for 1 month of any judge who, having jurisdiction, fails to schedule a hearing on a prerogative writ. Now, what are the prerogative writs? I'll scroll up in a second. But those refer to quo warranto, habeas corpus, procedendo, mandamus, prohibito, and certiorari. Now, the ancient rule is that each The ancient rule always has been, for hundreds of years, that if a demandant, as is the best term for the person that is, files a case and serves it on the respondent, the respondent has 3 to 20 days to respond. depending on the distance from court. If it's in the same town, 3 days. If it's on the other side of the country, 20 days. But essentially about as fast as is possible to move from one place to the other. And what this is saying is that the guy gets laid off for a month without pay if he doesn't schedule the hearing within the required time. And for each such violation, the penalty is doubled. So the next time it's 2 months, and it's 4 months, and it's 8 months. Pretty soon he's working for nothing, or in fact he's not working. So, and the burden of proof shall be on the respondent, failing which judgment shall be rendered in favor of the demandant. The suspension shall be doubled for each subsequent failure. Then we mandate the convening of the grand jury of 23, an important number, by random selection from each jurisdiction having a population of no more than 3,000 persons. That was the village I was speaking of earlier. When this country was founded, very few counties had more than 3,000 people in them, of which probably less than 10% were voters. So you could call a county meeting, have everybody who was qualified to vote in the county show up and probably meet in a single assembly hall or certainly on the town square. So they're all, within, less than 300 people, maybe only less than 100 people. Because, of course, a lot of them who are qualified aren't going to show up. But the grand jury of that age was supposed to serve that number of people. And that number of people had their own judge, their own sheriff, their own militia. They took care of everything themselves. By and large, nobody got paid for anything. It was all done on a voluntary basis. They mandate that no more than half the time of the grand jury be spent hearing bills of indictment, and that they shall have at least 4 hours to consider each bill unless they shall choose otherwise. Right now, in a county like Harris, the grand jury has less than 10 minutes to decide each bill of indictment. What are they going to do except rubber stamp the prosecutor? I mean, if the prosecutor's flooding them with bills of indictment, they simply don't have the time to give each one the attention it deserves. So what I'm saying is they've got to give it the time it deserves. An indictment is not something to be rubber stamped. It's something to be considered very, very carefully. And the other half of the time should be spent supervising public servants, making sure that government is working the way it's supposed to, making sure that potholes are fixed, bridges are repaired, children are taught, whatever needs to be done to make sure that it's done and done right, and that without wasting the public money. Then, to authorize grand juries to issue subpoenas directly rather than only through their courts. Right now, a lot of the deprecation of the grand jury is due to the fact that it's under the supervision of a court which can thwart their efforts to do their job. So one of the things that needs to be done is that a grand jury, once it is convened, needs to be independent even of the judge. And to be independent of the judge, it has to be able to issue its own subpoenas. And then, Item 14, authorize and direct grand juries to decide the jurisdiction or lack thereof, or the immunity of any official or any complaint brought before them. The grand jury actually does decide this, but it doesn't know it does. Let's say, for example, that somebody brings a complaint, to be criminal offense and to be civil matter, to a grand jury, and the proper jurisdiction for that complaint is not that court, but maybe a court in a neighboring county or in town, or maybe even a different state. The grand jury needs to be able to say, now wait a minute, where did this happen? That's on the wrong side of the line. Now you need to be filing your complaint with this other grand jury over here. We're going to no-bill you because you filed it with the wrong grand jury. But there's no prejudice in that. It's up to the other grand jury if they want to take it up, but we won't. Similarly, if somebody files a complaint against a public official, say a judge or prosecutor, and the judge or prosecutor says, well, I was doing my duty as a judge or prosecutor, so I'm immune. Complaint doesn't apply to me. The grand jury needs to be able to decide, well, now, wait a minute. Here's what your duties are, but on that particular occasion, that's not what you were doing. You weren't doing your duty when you did that. You were violating your duty when you did that. Therefore, you do not have immunity. And therefore, we are authorizing prosecution of you. So, next one. To authorize grand juries to order the removal of any impediments to access to them by members of the public. That means the grand jury controls access to itself. Now, yeah, it can hide itself in a room somewhere and keep everybody out if it wants to, but if somebody else tries to keep people out, they need to be able to say, no. These folks want to see us. Yeah, they can get to see us one at a time. Let them line up. First come, first serve. We knock on the door when each one gets his turn. But you don't get to keep them out. We keep them out if we decide to. Then, number 16, authorize grand juries to issue to any complainant or his designee, not just to public prosecutors, an indictment authorizing criminal prosecution. The standard used to be that most criminal prosecutions were conducted by private parties. Public prosecutors were unheard of for the most part. Then along the way, late 19th century, the caseload becomes so great that the demand was to pay people to be public prosecutors on a full-time professional basis. But as soon as that happened, the public prosecutors tried to keep private prosecutors from entering the fray. And that's a problem, because the public prosecutors may themselves be criminals. They need to be able to have private parties come into a grand jury with a complaint that, hey, public prosecutor over there is taking money to either not prosecute or to throw a case, or maybe to prosecute somebody who's totally innocent, but he's not a proper prosecutor here. We need a new guy to come in and deal with the situation. Either take over from him or maybe even go after him. Now, authorize grand juries to investigate any public or private enterprise whose activities may adversely impact the public and to report their findings. Now, let's imagine what that could involve. For example, can you imagine what would happen if a grand jury had investigated Enron or one of these financial giants like Lehman Brothers or Goldman Sachs or any of these companies? Okay, yeah, there are regulators. Guess what happens when the government has regulators? They mostly get overwhelmed or captured or complacent. They don't do their job. Regulation by regulators just does not work. What can work is grand juries. So imagine, let's say that you have some very large company and middle management is running things so that they produce nice quarterly returns for their shareholders. And the shareholders would just say, oh, we just love all these dividends. We don't know what you're doing, but just keep on doing it. And a grand jury suddenly knocks on the door and says, well, we're here to check you out. Well, you know, we've got trade secrets. We just can't let you come in here and browse around. Well, we understand. We'll respect your trade secrets. But we want to look over your books, your operations. We want to make sure that you're not conducting business in a way that because you're too big to fail, you're going to fail and take down the whole financial system with you. And it says, well, you know, we hadn't really thought about anything we're doing might do that. You know, we're pretty sure we're okay. I mean, are you sure that something we're doing might, you know, bring down the whole financial system? Yeah, that's a possibility. That's what we're here to find out. And maybe the grand jury pokes around a while. They don't know what they're looking for. They know that they're looking for something going wrong. Notice they don't have any particular standards, accounting standards, rules, anything like that, that probably were written for a situation that's 2 generations of economic collapse back. They're trying to anticipate what could go wrong from what's going on in the companies they're looking at. It says, you know, I don't know about these derivatives here. You've tried to explain them to us, and we don't understand them. And we're not sure that you should be selling something that we can't understand. I mean, do you really understand them? And, well, you know, we ask them a few questions and says, well, you know, we don't think you really understand them either. You know, we think that you are engaged in a highly risky business practice that is not in the interest of your shareholders. So, what we're going to do is we're going to issue a report. We're not going to reveal any trade secrets. We're going to issue a report to the public, so it's also going to be sending copies to your shareholders. And it says, look guys, they may be earning great quarterly returns, but the way things are going, we think this company is going to fail and bring the whole financial system down within a year if you don't do something about it. That's the way you get stability in the marketplace. It's not through regulation as we know it. It's through the grand jury system. So, now we're beginning to run out of time at this location, but I'm just going to go through the last few here fairly quickly. Number 18 is that we mandate that trial and grand juries be convened under the supervision of prior grand juries to ensure there's no stacking. In other words, the judge, the sheriff, people like that don't control, or shouldn't control, the way the grand juries are selected. Because there's good reason to believe that in many jurisdictions, the people in charge of picking the juries are stacking them. They're planting maybe people in the grand juries or the juries that are going to take control and do things for the people doing the picking. So the grand jury itself should pick the next grand jury. Then the mandate, the reversal of any court decision which treats a recent precedent as binding and for constitutional issues does not return to the original text and historical evidence of its meaning. Now again, this wouldn't work on the Supreme Court. You can't really tell judges what to do, but this is a basis for reversing any decision made by lower courts. And if you were to establish it, it would probably take a constitutional amendment. You would establish a legal culture which expects court decisions to be reversed if you make decisions based upon the most recent precedent only and don't ever go back to original meaning. Then 20, mandate reversal of any denial of standing of a party to privately prosecute a public right for injunctive or declaratory relief or on a writ of quo warranto. This gets back to something I said earlier. We need to be able to make sure that outsiders can come into the system. They shouldn't have to wait until they've been personally injured. The requirement that they be personally injured makes sense if they're seeking money damages. It does not make sense if they're seeking injunctive or declaratory relief, because they can do that on behalf of the public, with which they are acting as representative. And quo warranto, the prerogative writs generally are for anybody to use to defend the rights of anybody else, not just themselves. And then, number 21, mandate reversal of any disablement or deprivation of life, limb, or liberty for more than 24 hours Number 21, mandate reversal of any disablement or deprivation of life, limb, liberty for more than 24 hours, property, or parental rights without a trial by a jury of 12, including for contempt of court. Number 22, mandate reversal of any restriction on the practice of law without a jury trial. Number 23, mandate reversal of any court decision in which the public was not allowed to record the proceedings other than to conceal the identities of the jury. And 24, mandate reversal of any court decision in which the judges do not justify and publish their decision, clearly separating it from summary, findings, and dicta. Now these 24, if we could get them all established, get them all instituted, would go a huge way toward reversing most of the abuses that government now perpetrates. You can imagine a few others that are not included in this list, and I may be adding to it in the future. I'm inviting commentary by anyone who views this or visits the article, but I'm trying to reduce it here to a reasonably short list and that we can use as a basis for our program of reform activity. So I invite all of you to view it, to think about it, to try to understand it. I really realize that it doesn't contain a lot of explanatory material. You can find more of that at constitution.org and scattered all over the site. But if you can really understand the items in this list, you will have gone a long way toward being better able to defend your Constitution. Thank you very much.